Good evening, everyone. May I please request all the panelists to turn on their video? So I'd like to welcome you all to this discussion on fair and competitive e-marketplaces, the business user's narrative. I'm Vedika Mittal Kumar. I lead the competition law team at Vidhi, and I'll be moderating today's discussion. Now, India is touted to be the third largest e-commerce market, only behind China and the US. And the COVID-19 pandemic has further accelerated transition of commerce from offline to online channels. In a sense, it's become mandatory for sellers to be present on marketplaces if they want to reach a cross-cutting consumer base. So in this backdrop, today we are going to discuss on how to build an e-commerce ecosystem that works for everybody: consumers, independent sellers, smaller businesses, startups, open economies, and fair markets. And for this discussion, we have with us today a very distinguished panel, Dr. K.P. Krishnan. He's the IEPF Chair Professor on Regulatory Economics at the National Council for Applied Economic Research. Prior to his retirement from public service in 2019, Dr. Krishnan was the Secretary of the Ministry of Skill Development and Entrepreneurship. Dr. Christina Kafara, she's a senior consultant to Charles Rivers Associates in the UK. Dr. Kafara has over 2 decades of experience before the European Commission, competition authorities in several member states, and courts in several jurisdictions. Dr. Kafara specializes in the economics of digital platforms, and she's also a visiting professor at UCL London. And Mr. Rahul Mathan. He's a founding member of one of India's leading full-service law firms, Trilegal. He also leads their technology, media, and telecom practice and serves on the board of the firm. Mr. Mathan is a published author, a popular columnist, and was part of the expert committee that assisted the Government of India in drafting our privacy law. I welcome you all. So before we begin, just a few housekeeping rules. We'll commence the program today with a presentation on Vidhi's working paper, Fair and Competitive E-Marketplaces, the Business User's Narrative, by my colleague Manjushri. This will be followed by the panel discussion, and we'll reserve time at the end for audience Q&A. I encourage all audience members to please type in your questions in the chat box, and we'll be happy to take as many of them as we can at the end of the discussion. With that, Manjushri, I hand it over to you.
Thanks, Vedika. Just checking if my screen is visible.
Yes.
All right. Good evening, everyone. My name is Manjushri, and I'm a research fellow with the competition team at Vidhi Center for Legal Policy. I'm also the co-author of this working paper, Fair and Competitive E-Marketplaces, the Business User's Narrative. Over the course of the next few minutes, my goal will be to lay down a brief overview of what our paper has studied, what our findings has been, and where these findings can be plugged in order to start a conversation on regulating e-marketplaces from the lens of business users. Let's start by looking at what the Indian e-commerce market today looks like. As Vedika rightly pointed out, India's e-commerce consumer base is huge. We're the third largest e-commerce market in the world, just behind the United States of America and China, and we're also expanding very rapidly. Just in the previous financial year, 20 to 21, the e-commerce retail market segment grew by 25% in India. And this is despite the overall retail market shrinking by 5% due to COVID. India is also witnessing the growing popularity of e-marketplaces such as Amazon, Flipkart, Big Basket, Nykaa, Swiggy, Zomato, etc., where there is an intermediary that is laying down a platform for business users and consumers to interact with one another and make transactions. Now, this growing potential of e-commerce for India is not without problems. Let's look at what the problems look like, and let's start with how this e-commerce market is in fact organized. India's e-commerce market is undoubtedly concentrated, with very few e-marketplaces holding a large portion of the consumer-facing market share. This means that there are millions of consumers that have subscribed to e-marketplaces. And any seller or a business user that wishes to find their footing in this e-commerce market and transact with such e-commerce consumers must necessarily partner with these e-marketplaces. Now, this position that e-marketplaces have garnered for themselves, where they are acting as an indispensable intermediary between a seller and an e-commerce consumer, has made them acquire the status of a gatekeeper, where they're now in a position to dictate with whom and how e-commerce transactions through business users can happen. Now, this is not the only problem. The second problem is that some e-marketplaces perform the dual role of being both an infrastructure provider as well as have their own offerings on those e-marketplaces, essentially competing with business users that are already selling on such marketplaces. Now, these two issues, these two problems have given rise to several competition P2B issues, platform to business user issues in the Indian e-commerce market space. Now, we've dealt with these issues with abundant detail in our working paper, but two issues that we could perhaps highlight here is self-preferencing and deep discounting. Self-preferencing refers to a practice that e-marketplaces carry out where they mete out where some sort of preferential treatment is meted out to products of their own brand or products that the e-marketplace sometimes has a stake in. Now, a close example of this would be certain cloud kitchen partnerships that Vidhi has, for instance, or Amazon Basics and Solimo, where these products are sold on Amazon's e-marketplace. This is an example of self-preferencing. Another issue is deep discounting, where these e-marketplaces, in order to ensure that more and more consumers are attracted towards it and to retain its existing consumers, force business users selling on such e-marketplaces to sell their products at extremely low rates. And incidentally, some of these losses are being absorbed by smaller businesses. Now, these issues have been routinely leveled up. These issues have been routinely brought up and have been leveled up against e-marketplaces as being abusive. But we will look at how the Indian regulatory architecture is construed and how e-marketplaces are currently being regulated in India. So this is a snapshot of the relevant regulatory instruments that are applicable to e-marketplaces in India. Let's start with the Competition Act. Now, the Competition Act has looked at these issues in the past, or has at least heard of these issues being brought up before it in the past. But the biggest impediment that the CCI has faced in intervening and proactively taking action is that while there is a clear concentration in the Indian e-commerce market, in that several small players hold a large amount of the market share, there is no entity that is clearly dominant. And in the absence of a clearly dominant entity, the CCI has not been able to intervene under Section 4 of the Competition Act, because that is a prerequisite in order for the CCI to even look at whether these practices are abusive or not. The other statutory instruments mentioned here also have certain shortcomings. The FDI policy, for instance, is only applicable to foreign-funded e-marketplaces. So there is a gap as to what happens to domestically funded e-marketplaces that may engage in similar practices. The draft National E-commerce Policy 2019 and the Consumer Protection Rules of 2020 are largely consumer welfare centric. While they have many forward-looking measures, they are aimed at ensuring welfare of consumers and furthering transparency obligations such that it benefits consumers. The IT intermediary rules is an interesting example here. Although it recognizes power asymmetries between a platform and its business users, the nature of obligations in the IT rules are tailored specifically for social media intermediaries, and leaving, therefore, a regulatory gap in understanding what or who regulates P2B issues in India. Now, our working paper has also studied international responses with respect to how P2B issues are being dealt with in other jurisdictions. We have looked at the European Union, the United Kingdom, Germany, Japan, the United States of America, China, and Australia. And what becomes increasingly clear to us is that there is an emerging consensus to targetedly and selectively regulate certain platforms that are acting as gatekeeper platforms, and they're being called by different names by different authorities. In the EU, the preferred way of identifying these platforms are gatekeepers. In the UK, they're called entities with significant strategic market status. In Germany, they're called entities with paramount significance for competition across markets. In Japan, they're called specified platforms, and in the US, they're called covered platforms. But the idea is to selectively single out certain platforms that act as gatekeepers. This is despite whether they fulfill the burden of dominance or not, so that there is intervention possible against such platforms. The second trend that emerges to us from our study of all of these jurisdictions is that countries are now preferring to adopt ex-ante competition tools where the focus is on preventing harms as opposed to remedying them. The Competition Act today in India only intervenes ex post facto. That is only, for instance, when there is an abuse of dominance that has already occurred, the CCI can intervene to remedy this abuse of dominance. But competition authorities in the past have been reluctant to prevent harms from occurring in the first place. Now, there is definitely a move in terms of adopting ex-ante complementary instruments where the focus is on preventing certain unfair conducts as opposed to remedying them. Third, tighter scrutiny of mergers and acquisitions involving gatekeepers, in that in order to ensure that there is better regulation of what sort of entities these gatekeeper platforms are engaging in terms of are acquiring or merging with, there is tighter scrutiny around such transactions as well. And fourth, there is capacity building that's happening in terms of establishment of units, either within existing authorities or with new authorities that are being formed that are to specialize in understanding how to regulate digital markets and particularly aid in enforcement of such digital markets. So these have been our findings so far. And we have, although these are our findings, we have been reluctant to put out a complete set of recommendations yet. And instead, we have flagged a few issues that need to be discussed before we even figure out what model would work for India. So our working paper ends with a huge list of questions that we hope to carry out stakeholder consultations in the next couple of weeks and take inputs from the stakeholders and understand how a regulatory model for P2P issues in India must look like. So to sum it all up, the paper studies the existing regulatory gap in regulating P2B equations in the e-marketplace scenario in India. Second, this is important because, as Vedika mentioned, with more and more commerce moving into the online space, a regulatory model that accounts for welfare of all users, be it consumers or business users, is of paramount importance. Our findings has led us to a four-pronged assessment, as I just mentioned. One, there is a gatekeeper, there is a selective regulation of certain entities designated as gatekeepers, ex-ante competition instruments, tighter scrutiny of mergers and acquisitions, and capacity building in terms of having a dedicated digital markets unit in each of those regulators. And fourth, we hope that all of our findings inform future discussions insofar as we're able to start a conversation on how and why P2B issues are important in the Indian scenario and what a regulatory approach towards that should look like. Thank you. Over to you, Vedika.
Thank you, Manjushri. I think the presentation has perfectly sort of set the stage for the panel discussion. And with that, I move to our panelists now. Dr. Kafara, I'd like to begin with you. As we all know, e-commerce has several benefits. For consumers, it's wider choices, cheaper prices, easy refunds, doorstep delivery. Even for sellers, for that matter, where centralized warehousing options, easy payment options, targeted advertisements, and so on. In fact, one of the reasons for a light touch approach when it comes to e-commerce regulation is the fear that regulatory intervention will have a chilling effect on innovation. Do you agree with that, or do you believe that regulatory intervention can actually promote innovation and harness e-commerce for inclusive growth?
Thank you so much, Vidhi, and the Vidhi Center for this invitation. It's a pleasure to be here. I should start with what I think is obligatory disclosure for people who come from the private sector. As you know, I've been working as an advisor for many years. So my standard disclosure is that I've assisted various parties adverse to Google. I never worked for or against Facebook. I've done work for Amazon, for Apple, for Netflix, for Microsoft, and a few others. So that is a necessary statement to begin with. And I'd like to take your question a little bit broadly, if I may, and put a little bit of context around the question itself, because of course the focus of this session is on e-commerce, but as you've indicated, and Manjushri has also indicated, there is a much broader movement around what are we doing about digital platforms more broadly, which is a global question. And it is a global question that is originating from an anxiety that we have fundamentally about the rapid growth and the size of these platforms. They are very different. We're talking about social networking, we're talking about search, we're talking about e-commerce, we're talking about others, but the common feature which has spurred the current drive to think about dialing up antitrust, introducing regulation, is a general anxiety as citizens that we have about the size of these platforms and their role in our lives. At the beginning of the digital age, we were all thinking that the digital age was going to be this nirvana in which we were going to have digital diversity, we were going to be able to switch multi-home and go from this to that without any kind of lock-in effect, without any of that. In fact, things haven't kind of panned out that way, right? Our attention is being funneled into 4, 5 large giants globally that effectively control the way we search, the way we socially network, and so on, and the way we buy things, indeed, in e-commerce. And this in turn has spurred a great rethink about what is the real role of competition law, which is the big question which is being asked currently worldwide, and why we're pivoting to regulation. So in Europe, for example, and also in the United States until recently, the general view was, well, competition law is about ultimately addressing various forms of misconduct that a dominant company engages in. The big rethink is also questioning whether that is really the purpose, because of course, as you know, the discussion in the US and manifesting itself in the sort of the position of Lina Khan and others is more fundamental. Should we actually aim to address size and power per se, not just misconduct, right? Because the view is that behind the size, behind economic power, there is political power, and that is a concern. And antitrust should aim to distribute political power, to distribute economic power, because that is helpful to political power. So that is the context in which this discussion is taking place. And so we are concerned collectively about all of these different types of platforms. One of the kind of things that worries me about some of the current debate is that it tends to be a little indifferentiated. So we're all kind of worried about the platforms. But the reality is that they've all got very different business models. And that is a point that I made repeatedly. The way in which companies behave is driven by their incentives. And their incentives depend on the way they monetize, okay? So if you monetize, if you are a search engine and you are essentially free to users, you monetize through advertising, you're very different from an app store, you're very different from an e-commerce platform, you're very different from other things. And that is an important consideration when we think about these platforms and the problems that they actually raise and how we deal with them. I think that, and we'll talk about it in the second part, the approach to regulation should be more sensitive to distinctions between them. Now, when it comes to e-commerce in particular, the interesting feature is, of course, we're all worried about self-preferencing and the dual role. But the reality is that when we think about the way in which these platforms monetize, they make money either way. They make money whether they sell something themselves in their own name, an Amazon battery, and they make money through commission if a seller sells something. So unlike an ad-funded platform that only makes money when it shifts, it directs traffic to its own properties and doesn't monetize on organic search, an e-commerce platform makes money either way. So the incentive to self-preference needs to be thought about carefully. It isn't just the case that because you are the operator of the platform and you sell on the platform, you necessarily have the incentive to self-preference. This is something we have traversed in many industries, broadcasting. You know, if you're vertically integrated, you don't necessarily self-preference. It is a question. So I think, nonetheless, there are questions that need to be addressed when we think about the size and the power of these platforms. The big issue is the disparity in size. You are talking about giants, and you know, when we talk about e-commerce platforms in the West, we're talking mostly about Amazon, realistically. And so the reality of that is that you know, Amazon has almost total power vis-a-vis the sellers on the platform, and that inequality of bargaining power or bargaining position between two sides is something that we need to just be mindful of. So while I don't think necessarily an e-commerce platform has incentives to self-preference to its own product, I don't think that's necessarily true. It is perfectly reasonable and possible that there can be situations in which sellers are taken advantage of, or situations in which the data of the sellers is used in ways that are improper. It's a question we need to be looking at it. Or even the algorithm could be potentially not entirely fair if you put weights on it that favor yourself to some extent. So I think there is no question that some regulatory oversight is necessary. But the question that need to be looked at are things like, does the platform do anything to undermine multi-homing, for example? Because what we want is diversity. We want more than one platform. We don't want just a single one sort of eating up the entire space. Even though that single one may have incredible efficiencies, we want a more fragmented world. And if there are restrictions, like MFNs, like multi-homing restrictions, exclusivity, tying up the sellers or tying up the users in some way, then other platforms cannot thrive, cannot expand, cannot compete. So these are the things that from a regulatory and competition perspective, we should certainly look at. Final comment, are we in danger of undermining innovation with intervention? Listen, I've been around for very many years. And I remember very many years ago, I was involved in the original Microsoft case, 1999. And the kind of things Microsoft was saying at the time is, if you touch us, if you intervene, this is expropriation of our intellectual property, innovation will die. And of course, it isn't the case. It didn't happen. So this old chestnut that if you intervene, innovation will die is not credible to me. But there is no evidence for it, and there is no reason to expect it. Nature heals. You know, the instinct in Silicon Valley for innovation and for producing new startups are there. I think there is, on the other hand, some danger that some of the intervention is plainly silly, all right? So I've seen situations, and I won't name particular countries, but in which the regulator has said, now completely shut down all of the delivery operation, okay? Now the delivery is super efficient. What is the purpose here? Do we want to support the local delivery guys who don't have the capacity and the efficiency, so the consumer will get worse service because they're slower and more expensive? Well, that's a policy goal that the government can adopt, but it is not beneficial in terms of efficiency. So I think that there is scope for very, very silly intervention that is not justified. On the other hand, I think that oversight to the algorithm, to the contractual clause, to the way in which sellers are treated is absolutely appropriate and necessary.
Well, thank you, Dr. Kafara. I think those are some very insightful comments packed under 10 minutes. Thank you. And with that, I'd like to, move the discussion closer home. Dr. Krishnan, I'd like to ask you that, as Manjushri highlighted in her presentation, India is the third largest market. And in the last year, we've seen that in spite of COVID, e-commerce grew by a whopping 25%. And Dr. Kafara mentioned an important point that, the Western markets are sort of taking an objection to size itself and not just conduct. Do you think India as a developing country is sort of poised differently because, we might want that consolidation to sort of exploit the benefits of the resulting economies of scale? Or do you think that given that India has such a huge market, plus sellers, the SMEs are so vital to our economy, so it's actually the right time to sort of chart the regulatory course for e-commerce in India? Which of it holds true?
Thank you. Let me first offer my general remarks, and before I do that, a good afternoon to Dr. Kafara, good evening to my colleague Rahul, Manjushri and you, Vedika, and a very good evening to all the friends who are gathered here. First of all, a good report. I enjoyed reading it, especially the summary of international developments is something which I found very valuable. So let me again thank you for both the report and this opportunity. Very quickly, the main argument of the report itself is that ex post mechanisms to monitor the conduct of platforms broadly, I'm sort of summarizing it crudely in my language, have failed. And it is time to consider moving towards ex ante regulation. Now, clearly, I don't contest the general point. I agree with the general point, but I think we need much more specificity in terms of thinking about the regulatory design of this ex ante approach. Now, the description of the global developments in the report indicate a mix of different models. The proposals in EU and US seem to further empower existing agencies, EC, FTC as the case may be, while the UK seems to be moving in the direction of creation of a new unit, digital markets unit, if I remember exactly what you said, inside its competition authority. Now, if I have read the report correctly, I think it's page 45, where you seem to suggest that ex ante framework is something that falls ideally in the domain of a sectoral regulator, while the CCI, by and large in your schema, remains an ex post body. You do, to be fair to the paper, you do discuss later that creating a digital division within CCI could be an option. I think very close to the earlier page 45. But let's get back to this point in the course of the discussion. I'd like to come back to this. My thoughts on this, and I'll be quick in the initial set of initial remarks. This may be preferable to having a new platform-specific regulator, because I think competition issues lie at the heart of all that you've identified as concerns. And at least in the theoretical design, CCI has all the toolkits and the experience to think about them. Plus, it does ex ante regulation, at least on one issue. And Rahul can confirm this. He has done a lot more of this practice than I have. Review of mergers and acquisitions. So in one sense, there is no exclusively exposed aspect in its function, at least in the design. I think an additional point of support to this above argument would be what I think is an absolute failure seen so far in the coordination between CCI and sectoral regulators. One doesn't need to give examples, but if one has to, take the recent the Supreme Court, Vodafone, Airtel versus Jio matter, where the court has drawn attention to this conflict between CCI and other sectoral regulators. I have experience of this from another sector that I'm more familiar with, banking. Notwithstanding all the fine language, there is still complete lack of clarity on who actually is in charge of competition issues in banking. Now, I think increasingly, and this is a big concern I have, with regulators that cut across domains, a National Financial Reporting Authority or a CCI, and with sectoral regulators, I think this business of coordination between CCI and sectoral regulators is going to be an important part. And hence, having multiple agencies, CCI, Consumer Protection Authority, the proposed Data Protection Authority, with power to look into similar issues, will lead to confused jurisprudence and potential forum shopping. And I think having another platform regulator will only complicate this further. Now, while your paper is focused on the question of ex-ante regulation, there is also something to be said about CCI and how it can do much, much better in deciding on cases involving digital markets, even in the ex post review that we've seen. I'm sure you've seen the paper that Smriti, Avirup Bose and Ajay wrote, 2017, where they talk about some of the desirable improvements. There have been a whole bunch of papers thereafter, interoperability, acting in something like internet time. You can't take years to decide these kinds of cases. So the if I remember right, the Smriti Parshira paper also talks about the formal authority of CCI to designate platforms and firms as essential facilities and forcing interoperability. So I think there is clearly potential to do better there. There is also the larger question, and you draw attention to this, the political economy considerations, because there is a major foreign platform versus domestic sellers angle, which in a sense complicates this matter. Now, I'm, again, I don't clearly know the answer, but having dealt with FEMA for 5 + 2, 7 years in the government, using of FDI norms to reshape business models of companies, et cetera, is something which is I'm not very comfortable with. So to conclude, let me go back to basics. Public Economics 101 tells me 4 standard grounds of market failure: information asymmetry, concentration, public good provision, externalities. I don't know a 5th reason for state intervention. Here, clearly, concentration stands out, perhaps information asymmetry. But, let's focus on these 2 and let the design of, quote unquote, whatever regulatory intervention that we have in mind start from these basics. And let us not forget the power of the market itself. The same technology, the same market. For instance, whatever little I have understood of blockchain can potentially be a great answer to large platforms, at least in finance, where significant progress has been seen. So I would hesitate as much as market failure, at least in India, we need to be equally worried about state failure. I'll stop here. I look forward to a more engaging discussion. Thank you.
Thank you, Dr. Krishnan. So from what I understand, Dr. Krishnan sort of highlighted or is hopeful that in markets to sort of self-correct and newer technologies to sort of chip in. And he also highlighted as to how the CCI can take up a larger role. So, Mr. Mathan, with that, I'd want to know, what are your thoughts? Do you think an ex-ante regulation is required, or if we just sort of, fix the anti-enforcement bias that the competition regulator has, then we can deal with these false negatives and we may not even need an ex-ante intervention?
So first of all, thank you for writing the paper. As Dr. Krishnan says, I also enjoyed reading it. There are parts of it that you and I and both of you have spoken with me, and there are some parts that I don't fundamentally agree with, and perhaps we'll get into some of those things as well. Just also, both Dr. Kafara and Dr. Krishnan said so many things. It's difficult to unpack. I have slight points of nuance with all of them. I hope we'll get into that in the course of the discussion. So, at the outset, just to answer your question, is there a need for ex-ante regulation? Also, Dr. Krishnan's point, is there a need for a platform regulator or a platform regulation? And let me just put that also in the context of the other question that you asked him, which is this necessary for India? Because I think Dr. Kafara's experience is more international. And I wanted to make that point for India, and also to answer the question around that innovation and the chilling effect on innovation when you impose these regulations. And I think it's important to understand that in many parts, the relevant market in India that e-commerce addresses is very nascent when compared to other markets. And so when you look at concentration and you look at the effect of these platforms in those particular domains, you have to ask the question whether this is the right time to intervene or not. And look, as far as I'm concerned, there is certainly a chilling effect of regulation on innovation when that regulation takes place too early in the cycle of innovation. And you could squash an upcoming innovation or technology just by a very heavy hand on regulation. You're seeing what's happening to Bitcoin in the country. We're looking to completely ban Bitcoin. And as a result, the knock-on effects on all blockchain technologies, you're seeing the impacts in the country. So I believe that there is that nuance to be kept in mind in the specific Indian context. And then when you talk about the fact that the competition regulation is largely an ex-post regulation, I think in the context of certain digital platforms, when the effect of the regulation or the effect of the order is in relation to a practice, and I think the point really is that the regulator is coming into a new area with all the tools of the old era. And I think there is some challenge in applying some of those tools to this new digital domain. But when they do apply it to the new digital domain, the application of those regulatory tools is on the basis of some incident that has happened, but it has an impact shaping market behavior in the future with that type of behavior going forward. So in a sense, ex-post discovery of a problem has an ex-ante result on that entire sector. And that's not to be underestimated, as we've seen in the Google search case with regard to Shadi.com, and the similar case was the travel case in Europe. It in many ways shapes the way in which platforms will behave going forward in the future. And I think that should not be underestimated. So the reason why I'm presenting this nuance between ex-post and ex-ante is, if an ex-post regulation can have an ex-ante result, then the intervention and the timing of the intervention becomes critical. If you intervene too quickly, you will not allow the innovation to really reach full fruition. But if you intervene at a later point in time, at the appropriate point in time, you will punish the or you will guide the behavior in a more competitive manner. And so I think we should just keep that nuance in mind. And I think the last point that I will make at this stage is to urge us to be a little more creative in the way we would like to see competition regulated in the digital space. I think the instinct, and this has been the instinct from the Microsoft case, from the Explorer case, the instinct is to bring regulation to fix a problem that we feel that market behavior is not addressed specifically in the law and the regulation. We need to fix it with a regulatory intervention. When it comes to technology, we have other tools. In fact, we have technology as a tool itself. So what Dr. Krishnan mentioned about interoperability, I mean, what is the power of the platforms? It is exclusive access to data. If we can enable interoperability of platforms, we could, and look, there are many people trying to solve this problem. I think even in Europe, there is the Data Governance Act and the new Data Act. I haven't seen it, but there's discussions around that, which is focusing on making portability more effective. If we can enable portability, we will break down the silos in a way that isn't preventing the platforms from losing their commercial incentive. Because look, you cannot kill this may not be a goose that's laying the golden egg in that sense, but you can't build regulation that defeats business models per se. You've got to find a way in which to encourage that. So using data to enable, using technology to enable data portability is a really important element. And the other thing that I would say is, we've seen this a lot in India, and I'll give you examples in Bangalore in the pandemic. It may not apply to Delhi. I've heard it doesn't apply to other places. But what the e-commerce platforms have done for India is build out a tremendous infrastructure for e-commerce that never existed before. We've got fleets of delivery people, and they're not exclusively used by Flipkart and Amazon. They're used by everyone. I don't think anyone needs to build out the delivery side of e-commerce today. We can plug and play from any one of the many people that are available. We've got a best in class in the world, bar none, payment system. With UPI, anyone can pay anyone anything. What the e-commerce platforms today are doing is they're giving us discovery. All that they're offering us is discovery. The other parts of it, UPI is completely unbundled, delivery is completely unbundled. So if we can find a way to unbundle everything, we are actually, without really doing very much, allowing technology to provide alternatives in a way that I think if we use regulation, we're never going to achieve. Because as a lawyer, all that people pay me for is to find ways to get around new regulations that come. When the FDI rules said that you cannot have more than 25% on one seller, we just split the one seller into 4 companies. And so, you achieve the workaround for that rule. So I would look, in conclusion, to thinking about other ways in which to address this problem. And I believe that particularly in India, we are well placed to use these other mechanisms, given that we've unbundled 2 out of the 4 parts of the e-commerce stack.
I agree with a lot of that. I can react to it in the next. You want to ask me a question or do I react? Because there's a lot to like in what I heard.
Sure, Dr. Kafara. Please go ahead.
Well, I just wanted to, as this is a discussion, I just wanted to continue on this theme because I liked a lot of what I heard from Dr. Krishnan and from Mr. Matan, and I think it was incredibly subtle and important. Let me just again go back to, of course, you bring in the perspective of India. I'm an outsider thinking about what's happening in the world at large. And my experience there is that the reason why we are pivoting to ex-ante regulation is quite simply that in the West, antitrust has failed. This needn't be the case, but this is the reality. So Microsoft actually worked. What is the role of antitrust enforcement? It is ultimately to be a deterrent, right? Because it isn't that anyone cares about finding a particular company that much. You want others to learn the lesson and to behave properly. So in the case of Microsoft, you can argue that it worked. But when you look at the current situation that we have in Europe, starting from Europe, in the US after Microsoft, there has been permafrost for 20 years. I mean, competition law has not been enforced. We'll go back to the US. In Europe, we had the best intention. I can give you a comedy act as to why things have not worked. But in reality, think about the well-meaning efforts of the European Commission to deal with Google, for example. So the Commission in Europe started in 2010. What did they start with? The first case they started with was Google Shopping. Why? Because they had complaints. They had lots of complaints. So case selection was based on complaints. Frankly, who cares about comparison shopping? Ex post, is it a vital industry? Is it something that produces real breakthrough innovation? No, it's a slightly parasitic thing that does compare prices. So was comparison shopping the thing to die over? Not necessarily, but the Commission had that case. So the Commission continued to pursue that case between 2010 and 2015, asking Google lots of data, lots of questions, lots of things. In the meantime, Google was thinking, carry on over there. I'm busy occupying the mobile space with Android, right? And I'm shifting my monopoly from the desktop to the mobile. And the Commission keeps doing shopping. Then in 2015, they wake up and say, oh, gee, there is a monopoly in mobile already. It's Android. We need to do the Android case. So they start the Android case. And then meanwhile, Google has done occupation of AdTech, entire stack, and now the Internet of Things, and now the cars. So the point is that inherently, competition enforcement is 7 years too late because there is far too much lax in the process. And it is the parties themselves are grotesquely exploiting the process. Can I have an extension, receive a statement of objection? Can I have a 6 months extension? Well, no, you should do it in 2 months. 6 months, you really need? No, but you get it. So the point is that the cases against Amazon have been going for 7 years. The cases against Apple have been going for 7 years. Nothing is happening, right? Cases against Facebook, nothing is happening. So antitrust regulation, regretfully, has failed. So then we're finding ourselves here in 2021 and going, what do we do? What do we do? We have failed sort of patently. The US have begun to wake up, and the attorneys general are doing their cases and so on. But the cases aren't coming to trial until 2023. So nothing is going to happen for another 7 years. And the reality is that the platforms know it. And they know it perfectly well, and they've adapted. And they're so to say, yeah, okay, come after me, I'll see you sometime. And so the motion is, let's go and regulate. But then what is this regulation meaning? And I'll be trying to be sort of brief. In Europe, there is regulation, which is nothing else than competition law in a jar. Okay, so they've taken the same cases that we failed to do in competition, Amazon MFN, Apple App Stores, Google Shopping, Google Android. They've done the synopsis, and then these are the rules. So you got 15 rules, and everyone's looking at them and says, so what? Okay, because if you are a platform and there is a rule that says thou shalt not self-preference, what are you going to do? You're going to say, are you talking to me? I don't self-preference. Here's my compliance program. I'm fine. See you in Luxembourg in 5 years if you care to sue me. So the reality is that even regulation is going to fail, in my modest view, because it is not sufficiently bespoke, it is not sufficiently targeted, because the companies are ahead, streets ahead. And frankly, the position, I think, inside these companies, we will manage change. This is the prevailing mood. Do we have to change the App Store somewhat? Okay, we'll change it somewhat. It's not going to make Apple destroy, okay? Because everyone wants an iPhone. So to conclude, I think you're absolutely right when you talk about we need some more. We need something different. We need something different because we're not getting at this. And in part, it is this decentralized approach that, okay, you and Dr. Krishnan are talking about. Even blockchain is part of it. There is, what we need to think about is a different way to think about it. What these companies have is economies of scale and scope and network effects. And so I want digital diversity. I don't want to see these companies disappear or to break them up. I just want choice. And no one can grow in a world in which every form of network effect or economy of scope is proprietary. As you said, we need interoperability wall to wall. We need to create the network effects that are not proprietary. And we need digital infrastructure that is potentially common. There are kind of people who are thinking about this, because then you have identities that are not tied to a particular company, digital identity, payment systems that are not necessarily tied to a particular standard. You need protocols that are broader. And this is, I'll conclude here, I'll finish here, but I think if you look at the arc of history, so there's been antitrust, it didn't work. Now we're pivoting to regulation. It's a little bit like antitrust and it won't work for the same reason. It will do us something at the margin, not nothing but some. And unless we think of something better, we are not getting anywhere. I'll just stop.
Great. So Dr. Kafara, sort of raised doubts on whether regulation will work because companies are agile and they sort of adapt and move on, and ex post enforcement is certainly not a deterrent, but we are not sure if ex ante regulation will be a deterrent either. So, I mean, I read something very interesting in the Economic Survey of India. They quoted the Nobel Prize winning work of Herbert Simon and said that the future comprises of the unknown unknowns. And therefore, it's not possible to sort of fathom every situation and for regulation to tailor, to all of these future outcomes. And one of the solutions that they presented was that we should have principle-based regulation, somewhat like I think what the UK is trying to do, where you have broad principle-based regulation, and then you have more regulatory discretion at the enforcement level. So Dr. Krishnan, since you've been part of the system for decades, I want to know what is your view on adopting sort of principle-based regulation with regulatory discretion in the India context?
Thanks, Vedika. The discussion on principles-based regulation formally in India, you will find a lot of reference to it, for instance, in the report of Justice Sri Krishna in the Financial Sector Legislative Reforms Commission. We explicitly spoke about it. And in fact, during that time, with the help of the Ministry of Legislative Drafting, we actually got from the UK a set of 4 excellent legal draftsmen who conducted workshops on plain, I forget the name, plain English drafting or something, but focused essentially on principles-based regulation. Take our own regulatory legislations, for instance, the Sebi Act, good part of the Reserve Bank of India Act. In practice, almost all of the actual conduct of market regulation is done by Sebi. The act and the rules made by government, the parliamentary legislation and the rules, administrative law made by executive government deal with governance issues of the agency, terms and conditions of appointment, a whole bunch of agency-related structure, conditions, etc. And actual conduct of market regulation is entirely left to the regulator. So it is a principles-based regulation. The older legislation have reasonable clarity of objective, because the moment you talk about principles-based regulation, I think the objective needs to be very clear. If there are conflicts, conflicting public policy objectives, they need to be stated clearly, and some priorities for those objectives need to be clear. But, and it's a big capital B-U-T, this requires enormous capacity thereafter in the regulatory agencies. And I think that is something we need to worry about. I don't think we've been as quick in regulatory capacity building as we have been in creating regulators. we now, we fall down and we get up and find a regulator. I mean, the propensity to create regulators for solving every problem is something which worries me, because in a sense, we are getting rid of problems by saying, put it in a regulator and the regulator will solve it. The regulator cannot solve it if it's not a very clear-cut problem in one of the 4 buckets that we can put it into. But more to the point, principles-based regulation is a great idea in principle, provided the legislative drafting capacity of regulators is high. And here, a bulk of Indian regulatory agencies are not, very honestly speaking, firmly rooted in rule of law. They look at number of lawyers inside these regulatory agencies. The General Counsel of the Reserve Bank of India is a chief general manager, or maybe ED. Rahul, correct me if I'm wrong. And the internal capacity of the most important regulator of India in terms of the impact on markets, etc. The lawyers inside that office would be, I think, countable in these 2 hands. So to be able to carry out principles-based regulation in reality, I think you need far, far more capacity than we have today. I won't take that for granted. Let me stop here.
No, absolutely. I'd like to ask you a follow-up question to that. I mean, another option is to have specificity and to sort of say that we will tailor a code of conduct to each platform. But do you think we have sort of, the regulatory capacity, the public expenditure leeway to, sort of follow the Western world and have such targeted platform-specific regulations either? Dr. Krishnan?
Oh, sorry, I didn't realize I thought you addressed it to Rahul. Okay, so.
No worries. Do you want me to repeat the question?
Yeah.
So, Dr. Krishnan, my question was that, I completely hear you that, creating regulatory capacity as well as legislative drafting capacity for principle-based regulation is something that we can only aspire to, and we are not prepared for it at this stage. But then, the alternative that some countries are adopting is to sort of have tailored code of conducts for each platform. And Dr. Kafara also spoke of it, that, how in the EU Digital Markets Act, you can sort of see each regulation, you can say that, oh, this is applicable to XYZ platform, this is applicable to ABC platform. And it's very generalized, but some other countries are sort of tailoring a code for each platform. Do we have the kind of capacity that's required to do that either?
Today, I doubt it very much.
Okay. So then moving on, Mr. Mathan, we see that this sort of approach to designate and regulate platforms based on size, there is evidence of it closer home in the IT intermediary guidelines and digital media ethics code that was published earlier this year. And although it's applicable largely to social media intermediaries and news aggregators, but, they do sort of designate significant social media entities and regulate those. So what do you think are the practical ramifications of doing that? And also, I mean, I know that you've written that the IT rules are a sledgehammer that smash everything that comes their way, instead of being a carved out scalpel that sort of just weeds out the unknown. So what do you think are the learnings for e-commerce regulation from the IT rules?
Yeah, look, I mean, I think, first of all, in the paper, you have discussed this and you've brought out, I think, the answer to your question, which is essentially that the IT rules, even though theoretically they would apply also to e-commerce players just by the definition, that the obligations are not tailored towards e-commerce. They're very much to do with fake news or that sort of thing, and influence through content. So from that perspective, I think other than the fact that they use a number threshold, a discussion on the IT rules is not relevant from this perspective of dominance and competition and things like that. But if the question that you're asking is whether size as a threshold is relevant, I mean, I think obviously when you think about competition and when you say dominant market, very often that dominance is measured in terms of the influence that you can wield. And if you're working in a tiny segment of the relevant market, it's not believed to be. You've got to figure out when to invoke these provisions, and you only invoke it when the behavior is resulting in an appreciable adverse effect. And that's not going to happen if it's going to affect a small people. The small segment of the market that is being affected, of course, is upset and is, obviously they want some recourse, but we've got consumer protection for that. We've got, one-to-one remedies for that. The competition remedy applies at a threshold. Now, whether the threshold is number of users, whether the threshold is number of registered users, whether the threshold is number of active users, these are nuances that I think we've got to get into to understand whether there is an appreciable adverse effect. The reason why I wrote that line is that there's no such nuance in the IT rules. The IT rules essentially say, 50 million, 5 million users, and regardless of whether they're active users or not, if it's someone who signed up a long time ago and is not using it, they too are covered within this. And so you've got companies that have a small presence in India that also have to comply with these very onerous obligations. That not only has a chilling effect on innovation, it has a chilling effect on people being interested in extending their services to this country, which is clearly not the outcome that you're looking for. So I think the answer to this is yes and no. We have to look at size as a threshold because size has an unavoidable impact on appreciable adverse effect, but it cannot be blindly used as the measure. And while I have the mic, I just wanted to speak very briefly on principle-based regulation, because that's another drum I've been banging for a long time. I tend to agree with what Dr. Krishnan says, which is that it is the sort of tool that requires a tremendous regulatory capacity. And I think following from that, in order for it to be effective and really work, we need to have tremendous trust in the regulatory capacity. Because what you're doing with principle-based regulation is that you are stating principles and leaving it to the discretion of the regulator to apply, without necessarily prescribing regulations each time they apply it. You've got to give them that flexibility. So in addition to the capacity, and I think one follows the other. Once you've got strong capacity, in time, you will get trust. And at that point in time, we can see a well-functioning market with a regulator working on principles, the market trusting that those principles will not be used improperly, and then complying with the principles, almost to know that if I'm trying this new technology and applying this new innovation, I know that the regulator will think this way because, one, the principle says this, and the regulator can reliably be expected to interpret this principle in such and such manner. Having said all of this, I think it is, despite Dr. Krishnan's reservations, I think we cannot but use principle-based regulation when we're talking about technology for the reason that Dr. Kafara said. Technology moves so fast that if you want to enact a regulation before you regulate a technology, you are forever going to be 1 or 2 years late. I think courts are maybe 5 years late, but regulation, optimistically, is 1 or 2 years late. The only thing that is even later is our data protection law. Dr. Krishnan will know I bothered him while he was still in North Block 10 years ago, 2012, I think it was, when we first started working on a data protection law. It's 2021 and we still don't have a law. So I have no great hope that a regulatory solution, if it's a hard-coded regulatory solution, is useful. I think principle-based regulation is much better because you don't have to change principles as frequently. But it requires these other two things, both capacity as well as eventual trust that the market has in them.
No, absolutely. I mean, I think there seems to be a consensus that yes, principle-based regulation may be the right way to go ahead, provided, like Mr. Mathan said, that there is enough, there's no trust deficit in the regulator and our institutional capacities are up to the mark. Dr. Kafara.
Can I jump in on that? Because I don't necessarily agree with all of it, although I can see the logic. So I am a great supporter of the UK approach, which is a bespoke approach. The UK starts with general principles, okay? And it has a set of 3-4 general principles that are difficult to disagree with. The same is true of the European Commission. The DMA has got fairness and contestability as the two inspiring principles. Well, that's motherhood and apple pie, right? Who can disagree with the fact that one can be needing to be fair, one needs markets to be contestable, okay? My concern is that unless you if you're going to go down the regulation route, then the distinction between business model is such that to just mandate thou shalt not self-preference has got an enormously different sound to companies with different business models. It does work in a certain way for Apple or Facebook, not the same for Amazon, not the same for Apple, because they work differently. So the reason why I like the idea of bespoke contracts is because if we're going to go down the regulation route, we need to be reasonably tailored. Okay, I want to sit down and say to Amazon, this is what you gotta do. This is the 4 or 5 things that are specific to you that you gotta do, and we're gonna watch you. Don't use the seller data. Don't do MFNs. Don't reduce multi-homing opportunities. Don't wriggle away. The rules for Google are gonna be somewhat different. The rules for Apple are gonna be somewhat different. But they got to have some specificity, because otherwise, if you're not thinking about some precise, prescriptive thing that you're not supposed to do, everyone will wriggle out of it. As I say, what we will get is compliance program after compliance program. I comply, I don't self-preference. I really don't, honestly. So I think that's what's needed if we kind of want to go down that route, and we do, because some of it is necessarily required. So I hear you when you say that, of course, one needs the capacity and the ability to do that. One of the things that I like that the UK does, and I accept it isn't possible to do it everywhere, the UK started doing a number of market studies on these platforms, which are not intended to be leading to enforcement. They're just to inform themselves internally of where the issues are. And there is one on Amazon, there is one on Apple at the moment. They've done Google. And the point is that they want to get to the stage where when the DMU, the Digital Markets Unit, is operative, that unit will build on the basis of this knowledge of the technology of how things work, and then pursue targeted codes of conduct and targeted enforcement, which I think is a reasonable way to go. Last point. Look, we're not talking about dozens of platforms that are in scope. I mean, frankly, in Europe, we have used these thresholds, monthly users, capitalization, turnover, just pitching them at the right level where we might just about capture a couple of European firms. The reality is, no one worries about anyone else than the 5 GAFAM. And frankly, no one is going to enforce against anyone else but these 5. No one is going to enforce against Bookings.com, Airbnb, Zalando. All of that is irrelevant. As you say, they they're sizable, but they're not such that we worry. We're talking about the 5 of them. So the threshold you can play up and down, but this is where the enforcement is going to come. And the regulation is going to focus.
Thank you, Dr. Kafara. And with that, I'd sort of like to move the discussion towards regulatory architecture. Dr. Kafara, this one's for you. I mean, you just mentioned that in the UK, there's a digital markets unit that is being sort of constituted within their competition regulator, the CMA. So what do you think, what is the rationale for this approach versus, say, a specialized regulator or just, a coordination mechanism between other existing regulators? Like, why do you think is this the right approach?
Well, just simply because I think the competencies of the general regulator, the CMA, are relevant to also these particular markets. You need more. You need to understand some more the technology. The CMA has been very good at developing data capabilities, technological capabilities. They are actually ahead of the curve. They've also done work with the privacy regulator to understand the data piece. They signed a memorandum of understanding with the data regulator. And so there is within the agency a body of knowledge and competencies that is relevant. And to create a completely new agency separately from that would have been wasteful, right? In the same way as at this point, the European Commission is expected to be enforcing the Digital Markets Act, DMA, within DG competition. It's going to be done by DG competition, not by a new entity. So I think there is general consensus that the DMU in the UK is a subset of the CMA, but it's not a completely distinct agency because there are commonalities and competencies that need to be recognized.
Yes, and Dr. Krishnan, I remember you mentioned that creating regulators is definitely not the solution, and that seems to be the Indian approach at present. That if you have a problem, create a regulator to fix it. So do you think that for India also to sort of create a specialized body within the CCI is the right way, or do we simply sort of have some sort of coordination mechanism and divide the e-commerce regulatory space among existing regulators, or even a self-regulatory organization like we are seeing increasingly in fintech, telecom? What do you think is the right way to forward for India?
Thank you. Of these alternatives, I think for now, my sense would be unit within the CCI would perhaps be the way to go. But there are a whole bunch of, I think, design structural issues in CCI which one needs to address, and these have been commented upon. There are enough expert committees that have gone into it. So, throw in all of those comments, and then there are a lot of comments, including capacity and stuff like that. And, people who've dealt with, for instance, the Office of the Director General, the office which investigates, you need to really worry about capacity issues there. And in the area that we are talking about, it's not very easy to attract capacity in public sector agencies. Interestingly, I write a monthly column in Business Standard. My column tomorrow is exactly on this, on HR issues inside regulators in the context of a recent fairly famous public speech by the chairperson of the National Financial Reporting Authority, the authority that was created to regulate accounting standards, and it's a cross-cutting regulator, and it impacts, it's a regulator of professions carving out something out of ICAI, and yet has to interface with SEBI, with RBI, etc., etc. So very similar to what we are discussing in a different domain. Broadly, the sort of answer is yes. but with a lot of additional homework that needs to be done.
Thank you, Dr. Krishnan. With that, I'd like to move to Mr. Mathan. And, we are speaking of different options in terms of regulatory architecture. And, one thing that we hear very often is that in digital markets, the way to go is participative antitrust, where sort of big tech and GAFAM, like Dr. Kafara said, has a seat on the table. And this means including them in regulatory design as well as enforcement. How do you really think we can sort of balance the need for expertise along with ensuring that there is no sort of regulatory capture by big tech?
Yeah, look, I mean, it's a very interesting question, because I think it raises two issues. One is regulators don't necessarily have the deep understanding of the sector in all cases to be able to fully appreciate the nuances of what they're regulating. And that's the reason why in my writing I've said sledgehammer versus scalpel. We don't want sledgehammer versus scalpel, because sledgehammer versus scalpel, essentially, it's not when they go after the big players and whatever happens, look, they've got the market power, they've got the balance sheet to be able to withstand all of that. It's the unintended consequences on the small players. And that's what we inevitably see is the outcome of the sledgehammer. And so there is this urge to try and bring participation so that we can capture from market players their knowledge, so that we can understand that and incorporate that into the regulation, to make the regulation more nuanced. But in order to do that, you need very, very advanced regulators who can take the inputs from the participants, but not be influenced by those inputs to the point that results in regulatory capture. And no country is immune to this. If you look at the Boeing 777 issue, essentially FDA abdicated its regulatory responsibility. It was extremely aircraft had become so complicated, and there were just two people manufacturing them, essentially, that the expertise resided in the company. The company would essentially say what the safety parameters were, and FDA just didn't look at it in that level of detail. I'm oversimplifying, but I think if you think about that problem, it's a really good example of regulatory capture, where it's an extremely complicated area, and there isn't a wide range of experts available in the market. All of the expertise resides within the company that's being regulated. And a lot of those features exist in concentrated markets, which are the domains that platforms occupy. And so I think we've got to be very careful of that. I'm all for participation in regulation. I think we must invite all stakeholders to contribute their points of view. But we need someone, the policymaker, to be able to have the ability to weigh all of those various inputs, align them in the frame of reference of the regulatory objective, and then choose the policy direction. So I think it's important to get inputs, but it's extremely important to state what the regulatory objective is. And the regulatory objective for India is very different from the regulatory objective of the US and of Europe. And I'm mentioning these two because that's where we very often tend to borrow our regulations from. And we've seen that there are some unintended consequences of doing that as well. So I would say participation, but participation with a tight control by the policymaker. And the second and very, very important is write your policies, write your regulations in service of a regulatory objective that is very, very clear and that runs through the entire policy. If you can work those two, and in order to do that, you're going to need not just to invite the market participants, but also economists, lawyers, social science, whatever's relevant in that context. And we've seen lots of consultations like that. I think the PDP bill, India's data protection bill, had a wide range of consultations, and we see that increasingly in certain sectors. But we've got to, when we ask for comments from everyone, we're going to get all sorts of comments at all ends of the spectrum. And someone needs to be able to say, this is the way we're going to go. I'm sorry you're upset. We're not going to accept what you're saying. This is the way we're going to go. And that's much harder than it seems. And I know that people in these committees have a very difficult time, because after they've gone a particular direction, people say, oh, you didn't think about anything that I said, and this is biased and all of that stuff. But let's not get into all of that. I think that's sort of the challenge with it.
Can I make a final comment on this, because I know we're heading to time. The notion of participative antitrust that you mentioned, Vidhi, is something that is attributed to Nobel Prize Jean Tirole. Okay, so he wrote this article and said, this is all complicated. This technology is so terribly complicated. We need participation. We need to sit down with these companies and have a common understanding. That, for a man who is a Nobel Prize, was the least smart idea that I've ever heard. Because, of course, these companies love the idea. They love the idea of sitting and having tea at 5 p.m. with the regulator and explaining how the world works, and in the process, capturing them like nobody's business. So I think that participative, in the sense that there needs to be a tight company-regulator relationship, is a recipe for disaster, because it has proven over and over again that these kind of things end in tears. Apparently, the contradictory message I have, though, and this is really why this is so hard, is that without some input from the companies, these regulators are at sea. The technology is too complicated. And not only that, things are moving too fast, and they cannot begin to hope to understand what is going on. Take what is happening. So we're used to think, oh, Google bad, Facebook bad, and Apple looks after our privacy. Well, yes, they have this privacy initiative. There is a narrative that they are doing this in part to favor themselves in advertising. So this is privacy washing, right? We're doing certain things because we say it is ostensibly about privacy. We may want to do advertising ourselves. Amazon does advertising. So the point is, the business models are twisting and turning and evolving too. And no one in the regulator stands a chance in hell to follow what's going on. So, I mean, how are we going to do it? I mean, I think I agree. It is a difficult, I read a comment in the chat, it's very difficult to find an honest broker. There needs to be participation on the part of others, civil society, other sides, complainants, to try and inform the regulator. How else are they going to figure it out? I don't think it's an easy issue at all. I do fear the notion of a regulator sitting in an ivory tower, understanding nothing of the technology and issuing an edict. And that is nonsense. I accept that. On the other hand, sitting down and having tea is also a problem. So we need to design a system that has a little bit more chance of working, but it's hard.
Thank you, Dr. Kafara. I think we are very close to time. So if I could have just very brief comments from all the panelists on, very interestingly, Lina Khan, the FTC chair, remarked that, the singular focus on economic efficiency and low prices has warped America's anti-monopoly regime. So in this context, what, in your view, should the focus of competition law, what is the focus of competition law? Is it only consumers, or is it a wider goal? I know this is a very meta question and very loaded for closing remarks, but if I could just have, your brief comments on this. We can begin with Dr. Kafara, since you have the mic.
Okay, you just throw this at me like that. I could speak about this for about half an hour. But look, I mean, I'm a great fan of Lina Khan, and I think she has moved over to Windows is known in a way that is remarkable. I mean, we have certainly been victims of a shift in antitrust thinking towards a Chicago type of logic, which privileges efficiency arguments and so on. And that has gone too far. When I came into antitrust 25 years ago, that wasn't quite there. It needed to happen to some extent because everything was a bit mushy and not structured. And so we needed to have some structure in thinking about our categories of harm. Some things are not bad. Not every form of vertical integration is bad, okay? This is a Chicago point of view that I'm quite happy to stick with for a while. The problem is that things have gone too far. And this idea that we need to pursue just the consumer welfare in a narrow sense is really not worked, because it has led to, particularly in the US, effectively no enforcement. Mergers were always good. Mergers were always pro-competitive. Almost no conduct was anti-competitive. So, and frankly, I'm saying this as an economist working in this space, you'll always find an economist who's willing to argue these things. So, I mean, what Lina is reacting to is the fact that this has kind of led to disaster. We have gone too far. In Europe, it's been a little bit softer because we never had this very, this narrow consumer welfare sort of goal. It's always been broader, right? We care about competitors too, and so on. So I think the European notion of it is we also care about innovation. We care about other things, not just, you know, the narrow notion of consumer welfare. So I think that Lina Khan is right to really raise a flag and say, we've gone too far in the US in particular, kind of excusing almost everything. And we need to just get saner.
Sure. Dr. Krishnan, if I could have your thoughts on it. Do you think the focus of competition law is on consumers alone, or is there a wider goal?
Yeah, thanks, Vidhika. The literature that I have read, for instance, in the context of the US, I think makes a very compelling case for competition to be looking at, for instance, conditions of workers. This entire literature on the impact on wages in industries or in any sector with high degree of concentration. I think there is excellent quality work in the US. My familiarity with the Indian literature, would lead me to believe that we need a lot more work on this. And I think we currently, need to even focus on our first order issues of competition. And the way this regulator is structured, it has a long history. We in India are familiar with the twists and turns and the compromises that had to be done with the Supreme Court. So it's actually, even as a competition regulator, it is stillborn. And I think we need to first ensure that it becomes a full competition regulator of markets. And I think the second order issues are stuff on which I would like to see more empirical evidence. I think there is a problem, but I don't think, I know at least, that all the dimensions of this problem. So I would hasten slowly.
Sure, Mr. Mathan, your comments?
Nothing much to really add. I think, look, ultimately, this is a regulation of the market. And so to say that regulation of the market means only to look at consumers, I agree with Dr. Kafara. We've gone too far in that direction. Of course, theoretically, everything is indirectly related to the consumer and has a consumer benefit, but that won't capture what Dr. Krishnan says, which is the wages side of it. And we need to ensure that, gig economy and things like that, those sorts of things are protected. I think that if we take a framing, which is that we want to ensure a healthy market, and look at the inputs into the market and use that as the sort of rubric against which the regulator takes its actions, I think that would be appropriate. I think that, as Dr. Krishnan says, we are a relatively young regulator, and that has tremendous benefits, which is we can actually say that the Chicago School is not appropriate for the modern day and age. We don't have to adopt it at all. We have the ability to completely ignore it. I wouldn't say completely ignore it, but as appropriate. And then, in addition, we have the ability to take a close look at our market and what our market needs. And there's a lot that we can get out of allowing innovation. And it's not that regulation completely kills innovation, but as I said in my opening remarks, regulation too soon can kill innovation. And I think we should chart our own path in that sense. So I don't think what Lina Khan says is necessarily relevant at all for India, but it is certainly something that we should keep in mind in our current stage of competition regulation.
Okay, I think we have completely reached time. And with that, I'd like to thank our panelists. There are a couple of audience questions, but I think we are going to have to keep them for the next time. And I think we've covered most of what's been asked. But there are a lot of comments on the discussion, which, we can take back. And I think from today's discussion, a lot of diverse views have sort of come to the fore, whether it is, having a tailored code of conduct versus principle-based regulation versus CCI actually using its full arsenal that it has versus sort of, consensus that we need to promote interoperability. But I think one common takeaway is that status quo can't be maintained. Something needs to be done. And of course, there are diverse views on what that something should be. I thank all our panelists, Dr. Kafara, Dr. Krishnan, Mr. Mathan. Thank you so much. Thank you to Manjushri for that extremely insightful, informative presentation. And finally, I thank all our participants who joined in large numbers. Thank you for tuning in. Have a good evening.
Thank you so much. Bye-bye.
Bye.
Thank you. Thank you. Bye-bye.